Watching the breaking news show right here on CNN News 18. My name is Toya Singh. This afternoon, we're going to continue to bring you stories from across the country. Let's start though. I believe we have some breaking news coming in. Let's take a look. Since noon today, we've been focused on the Supreme Court verdict regarding same-sex marriage, the right for those who belong to the LGBTQIA community to get married. You remember the Supreme Court struck that down. The RSS is now welcoming the Supreme Court verdict on same-sex marriage. Remember, we've told you the decision regarded gay marriage, queer marriage. They've said this decision is welcome. Our democratic parliamentary system can seriously discuss all the issues related to this and take appropriate decisions. We've been bringing you updates since earlier this afternoon today. Key takeaways from the judgment that the Supreme Court passed. It was a 5-judge bench, and we'll bring you more details from what it is that the Supreme Court had to say. There were some split verdicts in different places. For example, 2 judges did feel that adoption should be made something that members of this community can do. However, 3 judges believed that that should not be the case. Like this, in some places, there were divisions. However, in multiple places, all 5 judges agreed to the same thing. Case number 1, for example, all 5 judges agreed that the right to marry was not a fundamental right. We have colleagues joining us to bring us more context on all of these developments. Earlier today, we also had, as you might remember, legal panelists, members from the LGBTQIA community, telling us about their own experiences over the last few years. Now, to bring you more on this particular slice of breaking news, Arun Danta with us right now to bring us more context. Arun, the RSS's response, where they've hailed what it is that the Supreme Court has said, they've also said the Parliament can pave the way for discussions on this. This stand very much synonymous with what the RSS has had to say in the past on this issue?
Well, that's right. RSS has been maintaining this fact on the legalization of marriage vis-a-vis LGBTQIA is concerned, and Sunil Ambekar, who's the national publicist in charge of Rashtriya Swayamsevak Sangh, is once again speaking on that line, saying that our parliamentary structure is well equipped with to formalize laws in this regard, and therefore once again reiterating the stands of all other top leaders of RSS who've been in fact talking about Parliament to intervene and make any sort of legislation which is required for this matter. So Sunil Ambekar once again reiterating that stand of the RSS.
Can you tell us, is this the limit of the statement, Arun? Because we know that some of the judges on the 5-judge bench, 2 in fact, believe that the current laws on adoption should be struck down, that single people, that queer couples should be allowed to adopt. Now, of course, that isn't something that turned into a law because only 2 of the 5 judges believe this. But does the RSS at all comment on other parts of the verdict?
Well, see, this is just a tweet of Sunil Ambekar. We'll have to actually, speak to them about the larger statement of RSS in this regard. But even in the past, we are going by the statements of various RSS leaders. Whenever they had spoken on these issues, they have always cited that parliamentary, structure that we have is something which will decide on these things, and therefore they have not actually, spoken on this on a larger scale. They have been maintaining this that people who are represented by the people of this country, they are the ones who have who have the rights to actually formulate law, and therefore the platform is Indian Parliament.
Arun, stay with us. We have different reactions coming in. First, though, let's take a look at what the Chief Justice of India had to say at 12 p.m. when the Supreme Court pronounced their verdict. Take a look.
Now my directions. A, the union government, state governments and governments of union territories are directed to 1, ensure that the queer community is not discriminated against because of their gender identity or sexual orientation. 2, ensure that there is no discrimination in access to goods and services to the queer community which are available to the public. 3, Take steps to sensitize the public about queer identity, including that it is natural and not a mental disorder. 4. Establish hotline numbers that the queer community can contact when they face harassment and violence in any form. 5. Establish and publicize the availability of safe houses or Garima Grahs in all districts to provide shelter to members of the queer community who are facing violence or discrimination. 6. Ensure that treatments offered by doctors or other persons which aim to change gender identity or sexual orientation are seized with immediate effect. 7. Ensure that intersex children are not forced to undergo operations with regard only to their sex, especially at an age when they are unable to fully comprehend and consent to such operations. 8. Recognize the self-identified gender of all persons, including transgender persons, hijras, and others, with socio-cultural identities in India as male, female, or third gender. No person shall be forced to undergo hormonal therapy or sterilization or any other medical procedure either as a condition or prerequisite to grant legal recognition to their gender identity or otherwise. B. The appropriate government and the Mental Health Care Act must formulate modules covering the mental health of queer persons in their programs under Section 29(1). Programs to reduce suicides and attempted suicides envisaged by Section 29(2) must include provisions which tackle queer identity. C. The following directions are issued to the police machinery. 1. There shall be no harassment of queer couples by summoning them to the police station or visiting their places of residence solely to interrogate them about their gender identity or sexual orientation. 2. They shall not force queer persons to return to their natal families if they do not wish to return to them. 3. When a police complaint is filed by queer persons alleging that their family is restraining their freedom of movement, they shall, on verifying the genuineness of the complaint, ensure that their freedom is not curtailed. 4. When a police complaint is filed apprehending violence from the family for the reason that the complainant is queer or is in a queer relationship, they shall, on verifying the genuineness of the complaint, ensure due protection. And 5. Before registering an FIR against a queer couple or one of the parties in a queer relationship, where the FIR is sought to be registered in relation to their relationship, they shall conduct a preliminary inquiry in terms of Lalita Kumari versus Government of UP to ensure that the complaint discloses a cognizable offense. The police must first determine if the person is an adult. If the person is an adult and is in a consensual relationship with another person of the same or different gender, or has left their natal home of their own volition, the police shall close the complaint after recording a statement to this effect. In view of the discussion above, the following are the conclusions. Queerness is a natural phenomenon known to India since ancient times. It is not urban or elite. There is no universal conception of the institution of marriage, nor is it static. Under Articles 245 and 246 of the Constitution, read with entry 5 of List 3 to the 7th Schedule, it lies within the domain of Parliament and the state legislatures to enact laws recognizing and regulating queer marriage. The Constitution does not expressly recognize a fundamental right to marry. An institution cannot be elevated to the realm of a fundamental right based on the content accorded to it by law. However, several facets of the marital relationship are reflections of constitutional values, including the right to human dignity and the right to life and personal liberty. This court cannot either strike down the constitutional validity of the Special Marriage Act or read words into the Special Marriage Act because of its institutional limitations. This court cannot read words into the provisions of the SMA and provisions of other laws, allied laws such as the Indian Succession Act and the Hindu Succession Act, because that would amount to judicial legislation. The freedom of all persons, including queer couples, to enter into a union is protected by Part 3 of the Constitution. The failure of the state to recognize the bouquet of entitlements which flow from a union would result in a disparate impact on queer couples who cannot marry under the current legal regime. The right to enter into a union cannot be restricted based on sexual orientation. Such a restriction will be violative of Article 15. Thus, this freedom is available to all persons, regardless of gender identity or sexual orientation. Transgender persons in heterosexual relationships have the right to marry under existing law, including personal laws which regulate marriage. Unmarried couples, including queer couples, can jointly adopt a child. Regulation 5(3) of the Adoption Regulations is ultra vires the Juvenile Justice Act, Articles 14 and 15. Regulation 5